Despite what you might have heard, Donald Trump still defrauded New York, but probably won't be paying $500 million as punishment. The verdict stands, but the punishment disappears for now. But this is complicated, and this opinion is a complete mess. Yes, a New York appellate court dropped a bombshell on Attorney General Letitia James's verdict against the Trump family. They upheld the trial court's conclusion that the Trumps committed fraud, but tossed out the nearly $500 million in penalties as an unconstitutional excessive fine. And thanks to a strange procedural twist unique to New York law, 4 judges with very different views stitched together a majority opinion that shut down the lone dissenter, keeping the most explosive question, whether James had authority to bring the case at all, out of New York's highest court. But like I said, this opinion is basically a mess that spans 300 pages. So let's break down how this happened, what it means, and what might happen next. Now, as you might remember, New York Attorney General Tish James prosecuted Donald Trump, 2 of his sons, and the Trump Organization under Executive Law Section 6312. This statute empowers the Attorney General to seek injunctions against individuals or businesses which repeatedly engage in fraudulent or illegal conduct. The law also authorizes restitution, damages, and in serious cases, the cancellation of a company's license to operate in New York. James advanced the case on 2 tracks. The first relied on fraud as an independent basis for liability under Section 6312. The second focused on illegality, rooted in alleged violations of criminal law, including falsifying business records, issuing false financial statements, insurance fraud, and conspiracy. To prevail, New York needed to prove that Trump and his executives intentionally inflated asset values in these statements of financial conditions, or SFCs, for more than a decade, gained hundreds of millions of dollars as a result, and continued operating without sufficient oversight to prevent future misconduct. Judge Arthur Engoron held a trial and determined that Donald Trump, his company, and its top executives were liable for repeated and persistent fraud under Executive Law Section 6312 in preparing and certifying as true Trump's falsely inflated statements of financial condition. And one of the most striking examples of fraud involved Trump's triplex apartment. The SFCs listed it as 30,000 square feet, which is almost triple its actual size of about 11,000 square feet. And when Forbes confronted the Trump Organization with public records proving the true size, the executives declined to correct the SFC. 4 days later, they finalized the 2016 SFC with the accounting firm Mazars, continuing to represent the inflated square footage. Another major misstatement involved Mar-a-Lago. The SFCs valued the property as if it could be redeveloped into luxury residences, even though Trump had permanently given up that right in 2002. After Palm Beach County rejected his request to develop the estate, Trump granted the county a conservation easement in perpetuity, barring residential development. In return, the county lowered Mar-a-Lago's assessed value to between $18 and $28 million, which gave him a significant property tax reduction. By disregarding those restrictions on the SFCs, the Trump Organization inflated the estate's value to between $347 million and $739 million from 2011 to 2021. Nevertheless, Trump publicly claimed that Mar-a-Lago was the most valuable property in the country. He insisted he could remove the deed restriction whenever he felt like it, and even suggested that a Saudi prince might pay over $1 billion for it. Judge Engoron rejected Trump's claims, concluding, quote, "There is no legal gray area surrounding the permanent nature of the deed restrictions. Accordingly, there can be no mistake that Donald Trump's valuation of Mar-a-Lago from 2011 to 2021 was fraudulent." Judge Engoron also found that the Trump Organization intentionally misrepresented Trump's minority partnership interest in Vornado Realty Trust, and the SFCs treated that stake as if it were $192 million in readily available cash, when in fact the assets were neither liquid nor under Trump's control. Companies such as Zurich and HCC relied on this inflated figure. A representative from HCC testified that the supposed $192 million was a meaningful underwriting factor since it suggested strong liquidity. Judge Engoron concluded that this misstatement was part of the broader pattern of financial deception underpinning the fraud finding. And Judge Engoron found that Trump knew or should have known about the inflated SFCs. Before his presidency, Trump personally approved these documents, delegating the calculations to CFO Alan Weisselberg and controller Jeff McConey, who worked with the outside accounting firm Mazars USA. And according to witness testimony, Trump directed Weisselberg that his, quote, net worth on the statement of financial condition needed to go up. To meet this demand, between 2011 and 2015, Weisselberg and Michael Cohen were tasked with reverse engineering the various different asset classes so that the assets aligned with the net worth figure Trump dictated. Once they reached the target number, Weisselberg would secure Trump's sign-off and send the SFCs to Mazars for finalization. And as the judge noted, this is the reverse of how SFCs are supposed to work. You do not start with a desired net worth and then manipulate asset valuations to match the target number. But after Trump was elected president in 2016, he appointed Eric Trump and Donald Trump Jr. as his agents with power of attorney over banking and real estate matters. From 2017 through 2021, they, along with Weisselberg, oversaw the preparation of the SFCs, and Weisselberg acknowledged that the Trump Organization's management representation letters assured Mazars of the accuracy of the information provided. and Mazars would not release the SFCs without their assurances. Although Trump argued that manipulation of the SFCs was essentially a victimless crime, Judge Engoron concluded that lenders, accounting firms, and insurance companies were victims along with the state of New York. He found that the banks wound up losing money by, quote, lending at lower interest rates than they otherwise would have. And after considering the evidence, the judge found that between 2014 and 2021, defendants overvalued the assets between $812 million and $2.2 billion. And he ordered the Trump defendants to disgorge approximately $354 million in ill-gotten gains plus interest. He ordered the court-monitored supervision of the company, including limiting the Trumps from making most business decisions, and he stopped just short of giving them the corporate death penalty. And of course, they appealed. Now, you can look up the address of all of Trump's properties online, but in fact, you can probably look up your address online as well. And in fact, it's entirely possible that your email address and phone number are online as well. And that's not surprising because data brokers vacuum up all of your personal data from all corners of the internet and sell it to anyone who wants to buy it. But you can fight back and take control of your personal data by signing up for today's sponsor, Incogni. Because Incogni removes your personal data from online data brokers by searching the internet, reaching out directly on your behalf, and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately or had your identity stolen. Now, I've personally been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years. I could never do that myself, so thank you to Incogni for doing weeks worth of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can always collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days with a 60% off discount and get a full refund if you're not into it. But if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word, at checkout. So sign up for Incogni or I'll see you in court. Now, as longtime LegalEagle fans know, New York's court system is a little bit different. The Supreme Court is actually the main trial court, effectively the lowest court. The Appellate Division handles appeals, and the Court of Appeals is the state's highest court. And the ruling that we're discussing here came from the first department of the Appellate Division. That means that there's still one more level of review before we get the final word on the Trump organization's fate. And the first issue that the appellate judges tackled was whether the Trumps were indeed liable under Executive Law 6312. And importantly, the majority concluded that they were. Quote, the record supports a finding of liability against defendants for conspiracy under Penal Law Section 105 in connection with falsifying business records, issuing false statements, and engaging in insurance fraud. Now, trial judges see witnesses, hear testimony, and evaluate credibility. And because appellate judges really only see a written record, the trial judge's factual findings are given a lot of deference. And on appeal, the controlling opinion emphasized that Judge Engoron's credibility determinations about witness testimony deserved great deference. For instance, Engoron found Trump's ex-lawyer, Michael Cohen, credible because his testimony was corroborated by other sources. Cohen testified that Trump set expectations, quote, like a mob boss, and that he was aware that the valuations were inflated. Now, the Trumps have contended all along that the entire case was based on lies by Michael Cohen, who was convicted of lying to Congress. But it's important to note that Judge Engoron's decision was not based on Cohen's testimony alone, far from it. Quote, as the record reflects, President Trump also had knowledge and access to the information contradicting the false and misleading assumptions used to inflate the estimated current values, such as the true size of the triplex apartment and his lack of control over his minority stake in Vornado, which the SFCs listed as cash. He knew about Mar-a-Lago's deed restrictions because he personally signed the deeds. He knew that Deutsche Bank would use the SFCs, and he had a financial motive. The trial record supports the court's inference that Donald Trump Jr. and Eric Trump possessed the requisite intent to defraud. That said, the 5 appellate justices here sometimes had different views of what the evidence showed. For example, the Trump defendants accused Judge Engoron and Letitia James of slapping a low valuation on Mar-a-Lago, which of course was a big blow to Trump's ego. But as Justice Renwick explained, quote, neither the Attorney General nor Supreme Court ever valued Mar-a-Lago at precisely $18 million at the low end or $27 million at the high end. Rather, Palm Beach County valued the property at between $18 and $27 million based on the deed restrictions, and the defendants themselves had previously acknowledged the county's valuations by withdrawing a tax appeal and agreeing with the appraiser's determination. Bafflingly, dissenting Justice David Friedman looked at the same evidence and suggested that a man as smart as Trump would never accept restrictions that lowered the estate's value. But the other justices said the trial record was clear. Trump's team had proposed the restrictions as a way to make the property more affordable to maintain. They wanted lower taxes, and that's what they got. Judge Engeron ultimately ordered the defendants to pay roughly $364 million, a figure that with interest has now grown to more than $464 million. Now, on appeal, the justices all agreed that the state had proven its case. The defendants had substantially overstated asset values. The panel also deferred to Engeron's credibility determinations, upheld his finding of repeated fraud and illegality under Section 6312, and confirmed that Trump's financial statements contain material misstatements spanning several years. So why then, if the fraud was upheld, did the court throw out the massive fine? Okay, here's where things get especially tricky and in the legal weeds. The First Department unanimously vacated the fine, but the justices had different reasons for doing so. We start with the opinion by Justices Moulton and Renwick. They concluded the disgorgement order was a fine that violated the Eighth Amendment's ban on cruel and unusual punishment. Now, under the Eighth Amendment, a fine is considered excessive when it is, quote, grossly disproportional to the gravity of the defendant's offense. However, the excessive fines clause was dormant until the Supreme Court's 1993 decision in Austin versus United States and Alexander versus United States, which recognized that both civil forfeitures and criminal forfeitures can qualify as fines subject to constitutional limits. The Supreme Court has said that excessive fine challenges are different from cruel and unusual punishment claims. That protection applies to states, and New York courts treat state and federal law the same. So, how do courts decide if a fine is grossly disproportionate? There's no rigid formula to make this determination. They look at three things: how serious the offense was and what harm it caused, whether the penalty matches the actual gains or losses, and whether the fine is compensating victims or just punishing the defendant. This case was complicated because the insurance companies and lenders weren't victims in the traditional sense. However, Renwick and Moulton observed that these third parties suffered real injuries. Quote, defendants' attempt to deny the gravity of their actions with blithe claims that none of the counterparties were harmed ignores a core reality. A bank making a loan seeks not only repayment, but also compensation for the possibility of default. Nicholas Haig, the managing director of Deutsche Bank Private Wealth Management Division, the entity that approved the 3 loans issued by that bank herein, testified that just getting repaid on the principal of the loan doesn't address at all whether we got properly recompensated for the risk we were taking. So it sounds like they agree that the third parties were victims, but the justices were skeptical about whether the penalties matched the actual gains or losses the company suffered. And they write, quote, while harm certainly occurred, it was not the cataclysmic harm that can justify a nearly $500 million award to the state. It is a virtue of the statute that the Attorney General may act, as she did in this case, before a potential catastrophe occurs, to deter further fraudulent business behavior by defendants specifically, and to police market behavior generally. However, having achieved these goals, the state is not entitled to compound its victory with massive punitive fine. So Trump's misrepresentations did in fact cause harm by exposing the banks to risk beyond what they bargained for, but the harm to lenders and insurance companies was not catastrophic and did not justify a penalty approaching $500 million. The judges also rejected the AG's methodology for calculating disgorgement. When a business is engaged in both lawful and unlawful activity, the state has to distinguish between the legal and illegal parts. And that's not easy to do. Here, the court found that 2 of the large transactions included in the disgorgement award, the $60 million sale of the Ferry Point golf course license and the $134 million profit from the old post office lease, were not reasonably tied to the proven fraud. And in fact, the Ferry Point license was never part of the state's liability theory. And the Attorney General did not rely on it in the partial summary judgment motion, and the appeals court ruled that the claims related to it were effectively abandoned as time barred. Moreover, the license required only no material adverse change letters, not SFCs, meaning the misstatements in the SFCs were irrelevant. If Trump had defaulted, the only remedy for the default would have been an increased security deposit. Because no ill-gotten gains were shown, Engeron couldn't order the Trumps to give up the $60 million profit they made on that sale. And as for the old post office lease, the state argued that Deutsche Bank would never have financed the project without Trump's SFCs, and therefore all profits from the sale should be considered tainted. But the appeals court held that the profits were also attributable to legitimate business factors, such as Trump's hospitality experience and real estate development skills. And since legal and illegal contributions to the profit could not be separated, disgorgement was inappropriate. These 2 transactions together accounted for nearly $195 million of the award. And since they say the Attorney General failed to demonstrate a causal link between those profits and the fraud, the court vacated the disgorgement in its entirety. They said, quote, while the injunctive relief ordered by the court is well crafted to curb defendants' business culture, the court's disgorgement order, which directs that defendants paid nearly $500 million to the state of New York, is an excessive fine. Now, Justices Moulton and Renwick ruled, however, that these sweeping injunctions would remain in place. Quote, this does not leave the Attorney General without a remedy. In contrast to its order on disgorgement, Supreme Court properly granted injunctive relief. The type of injunctive relief awarded includes extensive monitoring, thereby providing insight into the defendant's operations and creating guardrails to prevent future malfeasance. Its intrusiveness is its strength, which may be more effective in addressing the actions of defendants than the imposition of a one-time monetary penalty. For these reasons, it would likely have powerful deterrent effects on other actors in New York's credit markets, most of whom no doubt would prefer not to have outsiders monitoring their internal business practices and reporting their findings to a court. Being forced to pay for such monitoring, as defendants must do pursuant to Supreme Court's trial order, is an additional disincentive. Now that was pretty interesting because at the time of the verdict, some legal observers felt that the large fines were more likely to be upheld on appeal than the injunctive relief, because it's draconian to take decision-making authority away from the Trumps and give it to an independent monitor. But it seems to have worked out the other way. The justices found that injunctive relief was justifiable because the Trumps were highly likely to reoffend, citing Trump's fraud at Trump University, quote, allegations that the 58th Presidential Inaugural Committee overpaid the Old Post Office LLC to numerous defendants' benefit, the fraud related to Trump's nonprofit, and the tax fraud convictions of Alan Weisselberg, the Trump Organization, the Donald J. Trump Revocable Trust, and DJT Holdings. So the big takeaway is that the Trumps are serial fraudsters, but the justices are conflicted on the right way to punish them. And the 5 justices in the case were particularly fractured, and that's why there were 3 different opinions spanning over 300 pages. And the fact that 4 of the 5 judges agreed that the Trumps were liable is actually very important for purposes of appeal. So let's briefly look at the partial dissent by Justices Higgett and Rosado. Although they agree that the Attorney General had statutory authority to bring the action, they disagreed with the controlling opinion on the question of liability. They thought that Judge Engoron erred in granting summary judgment because the record left genuine questions of fact unresolved. They felt that the extent to which the lenders and insurers actually relied on Trump's inflated SFCs was an open question. For example, banks like Deutsche Bank conducted their own independent valuations of the Trump assets and applied deep haircuts to Trump's numbers. This could suggest that the misstatements were not really at all material to their decision-making. Higgett and Rosado thought that those disputes should have been resolved by a fact finder, either a judge or a jury, rather than on summary judgment. Because to decide a case on the papers on summary judgment requires that there not be material issues of fact that are unresolved. Which is not to say that they didn't think Trump did something wrong, they just thought that that needed to be decided by a jury. Higgett and Rosado also voiced concern about the disgorgement award, noting that the absence of causal linkage between the alleged fraud and the financial benefits the trial court sought to claw back. While they did not go as far as the controlling opinion by Moulton and Renwick in applying the Eighth Amendment's excessive fines doctrine, they flagged some of the logical flaws in the damages calculus. They would have vacated the judgment in its entirety and remanded for a new trial on both liability and remedy. And then there's Judge Friedman's dissent. He took the most sweeping and Trump-friendly decision that borders on a Trump screed. His position was that the Attorney General lacked authority under Executive Law Section 6312 to bring the case at all. He echoed Donald Trump's view that the entire case was a political witch hunt, arguing that Section 6312 was never intended to authorize sprawling civil fraud prosecutions of this kind, particularly when no private party suffered direct measurable losses. He accused James of trying to destroy Trump politically, quote, plainly her ultimate goal was not market hygiene as posited by Justice Moulton, but political hygiene, ending with the derailment of President Trump's political career and the destruction of his real estate business. The voters have obviously rendered a verdict on his political career. This bench today unanimously derails the effort to destroy his business. So although the First Department panel split into 3 camps, the opinion authored by Justices Moulton and Renwick controls. That's because under New York appellate practice, when no single rationale commands a majority, the judgment of the court is determined by the narrowest grounds on which a majority of justices agree. Moulton and Renwick upheld liability but struck down the disgorgement award as unconstitutional and unsupported. Ordinarily, with Higgett, Rosado, and Friedman all voting to vacate, the majority outcome would have been a remand for a new trial. That type of order is not final and under New York law would not create an automatic right of appeal to the Court of Appeals, but Higgett and Rosado joined Moulton and Renwick on the decree affirming liability, vacating disgorgement, and reversing sanctions. That move ensured that those results became the judgment of the court. Friedman's dissent was left isolated, making the Moulton-Renwick opinion the operative holding. And they did that for a very in-the-weeds reason. Under Article 6, Section 3 of the New York Constitution and CPLR 5601, a party can appeal to the Court of Appeals, the highest court, as a matter of right if at least 2 justices on the appellate division dissent on a question of law. This is known as the 2-dissent rule. Had another justice joined Friedman's view that James lacked authority to bring the case, that would have triggered the rule and forced the Court of Appeals to take it up. But because Friedman stood alone, the higher court cannot review the AG's authority to file in this particular case. And as we all know by now, if the case had been remanded for a new trial, it might never go to trial again. In Trump versus US, the Supreme Court gave presidents sweeping immunity from criminal prosecution for official acts committed while they're president. So what about standing trial for acts that a president committed while a private citizen? Well, the Supreme Court has never directly decided whether a sitting president can be criminally prosecuted and stand trial for acts committed before taking office. The Office of Legal Counsel has twice issued memos taking the position that a sitting president is immune from criminal prosecution while they're in office, mainly because a criminal trial would allegedly undermine the executive branch's ability to function. Now, this isn't binding law, But it's hard to imagine the current Supreme Court allowing Trump to stand trial for anything while he's the sitting president. So for now, Donald Trump, our president, can't apply for loans from institutions chartered in New York and can't serve as a corporate officer or director for 3 years. Don Jr., Eric Trump, Weisselberg, and McConey can't serve in management roles, and the Trump Organization must retain an independent director of compliance. And the independent monitor's team has more authority and at least 3 more years to watch the Trump's every move. But you can bet that everyone is going to appeal this decision as well, so stay tuned because this is not over yet. But this will all go back down to the trial court and we'll see what the updated fine is. But of course, when this goes back to the trial court, the state of New York might need a good lawyer. Luckily, I know a guy. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could. But what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.